Ms. Bridgewater, do we have a reset date for the SAP?
Sure. Good afternoon, everyone. Our reset date is going to be April the 19th for the SAP calendar.
Okay. All right, let's, it's almost 2 o'clock. Mr. Ford, good afternoon. Good to see you. It's been a while.
Yeah, good afternoon, Your Honor. I got to say, whoever has the idea that we've got to go through MAG court to get this Zoom link has respectfully dropped the ball. It is a colossal frustration for counsel to get the links. I don't know if we can change the process or not, but that's my 30 seconds worth. Thank you. Good afternoon, Your Honor.
Good afternoon, Mr. Ford. I'm sorry, I wasn't aware that anyone had to go through magistrate court to get the links. I thought the links were sent out
No.
Directly.
We have to get magistrate court to respond by emailing MAG court, and they're 8 out of 10 times non-responsive. And it just makes it very difficult for a retained counsel to give the semblance of doing his or her job if you can't become part of a hearing.
No, I understand, Mr. Ford.
The jail folks tell you they don't have the link, they can't give it out. So
can you call the clerk's office and have them send out the link to you?
You have to email them and just hope that they respond.
Okay, now that I know that there's an issue, Mr. Ford, I can help address it. I didn't know there was an issue before, but I'm happy to see what I can do to help address that issue.
There's got to be an easy way to address this. I appreciate you. Thank you.
You're welcome.
Judge,
All right,
excuse me, I'm sorry for interrupting.
Your Honor, this is the other Mr. Ford. Good to see. Haven't seen you in a while.
Great afternoon, Mr. Ford. Good to see you also. And Ms. Lewis, good afternoon.
Good afternoon, Judge. I'm sorry for interrupting. For Mr. Tom Ford, is he addressing state court? Because magistrate court is a totally different link than we are with the SCA counter. So I just want to get clarified that it's not state court of Fulton County and magistrate, because we are two different identity. So magistrate court won't know about the SCA counter because it's not underneath their courts system. It's underneath state court criminal. So we would when we find out that there's attorney on record for the first appearance and stuff, if you call the clerk's office of state court in J150, we will be able to give that link out to you. But magistrate court is a totally different identity from us.
I understand. This fellow turned himself in yesterday, expecting to be on the 9 a.m. first appearance calendar, and MAG court said they had no record of it. And then we kept calling and finally confirmed he was on today's 2 o'clock calendar, even though he had a bond already in the system. And we finally got a response to be here. So I don't know where the disconnect is.
Everybody's confused about the new calendar. This is a SCA counter, it's a new counter. So there's still a lot of confusion in between magistrate court and us in the separation of that. They have to be booked in by a certain amount of time to be pulled on the pull sheet to be placed on the counter. But if you have any other questions or directed, you can always call state court criminal division, or you can personally call me, Katrina Lewis or Mr. Jordan, and we will try to address your issue.
Thank you, Ms. Lewis.
You're welcome.
Okay, so let's see. South Annex is requesting to take position number 7, Ms. Taskin first. So if there's no objection, let's go to the South Annex and begin with Ms. Taskin. Who's representing Ms. Taskin this afternoon?
Craig Lewis, Judge.
Oh, good afternoon, Mr. Lewis.
Good afternoon, sir.
Good afternoon, Ms. Taskin. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we are holding by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, she does, Judge.
All right, thank you. South Annex, can you unmute for me, please? Thank you. Ms. Taskin, you've been charged in case number 22 CR 002031H with battery family violence. Is there a history? Mr. Howard, good afternoon.
Hey, it's a 4th arrest. Last arrest was 2014 for battery out of the cab that was dismissed. 2012 suspended license NOLO. 2002 first offender shoplifting.
Okay, thank you. Good afternoon, Mr. Segura.
Good morning. Good afternoon. Okay, I'll begin. This incident occurred on April the 4th, 2022 at the incident location at 3200 Alexander Circuit, Northeast Atlanta. In this situation, officers arrived at the incident location and asked Mr. Calvin Freeman, Calvin, common spelling, Freeman, common spelling, to tell the police officer as to what happened. He said that when the defendant arrived at the residence, she began to knock it several times, believing that another female was present, which caused a verbal altercation. Mr. Freeman was then asked to leave the residence by the defendant, which Mr. Freeman attempted to do so. However, upon exiting the apartment to the parking lot, the verbal altercation became physical when the defendant charged at him and began to swing at him, at which time Mr. Freeman pushed the defendant in an attempt to avoid being hit and get away from her. Mr. Freeman also stated that during the time he received scratches and was cut under his right eye by the accused, in which the police also observed there was some redness, swelling, and a cut. Alongside, the defendant stated that the whole incident occurred was when the defendant tried to enter the residence, but because she didn't have a resident key and the key she did have did not function, and mostly blew up from at that point. Your Honor, we're asking for a $4,000 surety bond, no alcohol, drugs, and weapons, 1 day anger awareness, a stay away from 3200 Alexander Circle, Northeast Atlanta, and no further contact with Conrad Freeman. Make recommendations based on these facts, and because I'm deeply concerned about the safety of Mr. Conrad Freeman. These two are in a relationship and both live in the same residence, so deeply concerned as to what could happen if the defendant is allowed to be released and come and visit Mr. Freeman. And also noting that this arrest only happened just yesterday. We believe there's not long of a cooling period to actually cool down any type of feelings. Thank you, Your Honor.
Have you spoken with Mr. Freeman?
We haven't yet.
Okay, Mr. Lewis?
Judge, is Mr. Freeman also detained? I got a bit of confusion in the narrative there. Is Mr. Freeman also detained?
He was arrested for a different charge.
Okay.
Okay, all right, thank you.
Thank you, Judge. Judge, we're going to ask the court to give a signature bond in this particular case. If I understood correctly, and I was a tad bit disoriented in the narrative, the other person came to this residence where this client was, where this defendant was. If my understanding is correct. Judge, my client was her mailing address is in Beaufort, Georgia. She owns a number of pieces of property. My client is also a 6-year veteran of the federal government, where she is still employed at this particular point in time. Judge, she is a lifelong resident of the state of Georgia. I heard about an arrest for a charge that was similar that was dismissed. I also heard that she had a traffic arrest as well. I heard pretrial services tell us that there's a total of 4 arrests, and I think the other one was a traffic-related event as well. Judge, she being a lifelong resident, being gainfully employed, having no other convictions on her record with respect to a charge like this, I would ask the court to SOB her through the jail. Any amount doesn't really make a difference to us. Stay away from the purported victim is not objected to. The violence awareness class, however, is objected to. That presupposes that she is guilty. And so we would absolutely object to that. Judge, once the final issue is that she is DNQ for public services. So this is the endpoint for indigent defense. That's all.
Does she have a reason to go back to that location on Alexander Circle, Mr. Lewis?
Let me ask this question to her in open court. Is that one of the properties that you own, or is that not a property that you own?
That is a property that I own. That is my investment property.
Okay.
And does Mr. Freeman have a reason to be there?
He was living there.
Is he still living there?
His belongings are there.
Okay. Well, since she can't be around Mr. Freeman, then she's not going to be able to be around that property at the present time. I am going to give her a signature bond, a $2,000 signature bond through pretrial. No further contact with Mr. Freeman. At this point, stay away from the Alexander Circle address. No drugs, alcohol, or weapons while out on bond.
Yes, sir.
Judge, may I ask a modification, even though you've done that, and we appreciate that. I heard her say investment property. Can we change that to a no violent contact and they stay away from that location? That way she can conduct business. Oh, I lost you, Judge. I don't know if
no
it's
one
you or
has
me.
spoken with Mr. Freeman. I'm reticent to allow her to go back until someone speaks with him.
Oh, no. I don't want her to go back, Judge. That we're not asking for that because I share the same concerns that you have. What I'm asking is a no violent contact so that she can work through a third party or receive phone calls, that being an investment property, he being a resident or a tenant there.
Well, if I say no violent contact, then that means that she can be around him. And
you're right, Judge.
Okay.
I see what you're saying.
So she can go through a third party to deal with her property if she wants to.
Okay, thank you, Judge.
I have no objection to that. She just can't deal with at
him
this
directly.
point, Mr. Freeman directly. And she'll have to have somebody else deal with that property while this is pending. Okay.
Yes, sir. Understood. Thank you, Your Honor.
You're welcome. Good luck to you, Ms. Taskin.
Thank you, Your Honor. Thank you.
You're welcome.
That concludes my business again, sir. May I be excused?
We'll see you next time. Yes, have a good afternoon. Be safe.
You as well.
Union City, you can keep going. I'm sorry. Go ahead, Union City. You can finish up.
And Ms. Johnson, that was Sergeant Johnson. That was I heard the judge say South Annex, but that was all me.
Okay, that's fine. Thank you.
Yes, ma'am.
Ms. Evans, come on. We got Ms. Evans, position number 6.
Good afternoon, Ms. Evans. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video? Yes, I'm sorry.
Yes, sir.
Okay, thank you, Ms. Evans. You've been charged in case 22 CR 002028F with simple assault, family violence. Is there a history, Mr. Howard?
Second arrest. Last was 2009, given false name, dismissed.
Ms. Falk, good afternoon. Is this your case?
Yes, it is, Your Honor.
Okay, you can proceed.
All right, Your Honor, this happened on yesterday, April 4th of 2022, over at 100 Lakewood Way, Southwest in Atlanta, Georgia. Officers initially responded out to that location in reference to a domestic dispute. Upon arrival, they spoke to Anthony Ardistor, that is ARDISTR. They also spoke to a first responder who stated he had observed the defendant running around after Mr. Ardistor and throwing rocks at Mr. Ardistor while their 6-year-old child was in Mr. Ardistor's vehicle. Officers spoke to Mr. Ardistor, who stated that the defendant showed up at his job on Moreland Avenue. An argument took place. They then drove to the incident location. Another verbal dispute occurred, at which point the defendant both threw rocks at Mr. Ardistor as well as sprayed pepper spray in his direction, which is why police were finally called out. Just to note, Mr. Ardistor has custody of their child who was in the vehicle, the 6-year-old child who was in the vehicle when this all occurred. The state's recommendation, Your Honor, in this case is a $1,000 surety bond, that there be no further contact with Anthony Ardistor, and that the defendant stay away from Mr. Ardistor's place of employment and his residence. We are also requesting 1-day anger awareness and no alcohol, drugs, or weapons. This is not a typical he said, she said. We have a third party who has nothing to do with any of these people watching her run around a vehicle chasing after Mr. Ardistor, throwing rocks at him. The defendant's own admission was that she threw rocks at him and pepper sprayed him. In addition, she stated that he had not physically placed his hands on her to warrant any of this behavior. And that was what the police the warrant informed us. And we do have concerns with her showing up at his job and then this continuing to escalate off scene. So that is why we're asking for that stay away from both his residence and his place of employment, and that no further contact, because there just hasn't been enough cooling off period. And this happened again in full view of a third party. So we are concerned at how this escalated so quickly. For those reasons, the state makes our recommendation.
Ms. Falk, is the Lakewood Way, is that the residence
It is not, to my knowledge, it is not the residence or it is not the residence or his place of employment. We do not at this time have the police report. So unfortunately, I do not have the information about where Mr. Artister resides, which is why I gave the very general stay away from his place of employment or his residence.
Okay. And I take it you haven't, no one from your office has spoken to Mr. Artister as of yet?
Let me just double check on that, Your Honor, because I don't want to misspeak. Let's see. Okay, so from what we have, they are not currently in a relationship, do not live together. They do share 2 children, and I misspoke. The children are ages 1 and 4. He does state he wants contact, and he did state that he does not recall the defendant spraying pepper spray and that she did not actually throw any rocks, which I find interesting because, again, we have a completely separate third party who observed her throwing rocks at him. And he said he does not remember the pepper spray, which is also interesting because the defendant herself admitted to spraying pepper spray to the police. So we have a situation in which I definitely think there should be a stay away and no further contact because there seems to be some discrepancy in the statements from the Mr. Artister versus what was actually observed by a third party who does not know either of these 2 individuals.
Okay, thank you. Who's representing Ms. Evans?
Your Honor, I apologize. Ms. Gant is having some issues. Public Defender Gant is having some issues getting into the Zoom call. I saw her name in a box down there, so I thought she was okay, but it appears she is not on. I see she's trying to connect now. So I did put in the chat to the court that she was having some issues trying to get on the Zoom call. But when
Yes,
I saw,
yes, I was aware of it, and I've been trying to work with her.
okay.
Can you hear us, Ms. Gant?
She's logged on as a phone, and she's trying to get her video together. So I don't know what is going on with her computer per se, but she's logged on as the call along with the video. So I don't know.
I see her there. We'll continue to work with her. Do we have anybody else at the South Annex? South Annex?
Yes, sir.
Okay, no, let me, hold on. Ms. Gant, can you hear us now? Yes. Okay, we can't hear you. So we'll continue to work with Ms. Gant. South Annex, do you have anyone else there that we can go to while Ms. Evans' counsel gets on the line?
Yes, sir. We have position number 7, Ms.
Okay.
Hughley. Come on.
Who's representing Ms. Hughley?
I also think Ms. Gant is representing her as well, if I'm not mistaken.
Okay.
Your Honor, I have most of the positions that it's the latter part of the calendar, except for Alvarez and Cantrell.
All right, so are those the only 2 we have left at the South Annex?
Yes, sir. Yes, sir. These are the only 2 that's left.
Okay, Ms. Gant, can you hear us now? Yeah, we can't hear you though. So what we're gonna do, South Annex, is we're gonna go to Courtroom 2. And we'll be back with you as soon as we get Ms. Gant back on the line.
Okay, no problem, sir.
I'm sorry about that.
That's okay.
Courtroom 2, who do we have?
Position number 9 first, I'm sorry, 19 first. Ms. Wilson.
And who represents Ms. Wilson?
I do, Your Honor.
Okay, good. Good afternoon, Ms. Wilson. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Ms. Wilson, you've been charged in case 22 CR 002038G with battery family violence. Is there a history, Mr. Howard?
8th arrest. Last was 2019 for battery out of Doraville. It was dismissed. 2019 suspended license arrest. 2017 suspended license. More suspended license. She had a disorderly conduct conviction from '06. That's it.
Okay. Good afternoon, Ms. Hartman. Is this your case?
Yes, it is, Your Honor.
And let me apologize. I neglected yesterday to welcome you to the court. I think it was your first time appearing in front of me. So you're very welcome. We're glad to have you. Okay.
Thank you, Your Honor. Thank you very much.
All right, you can proceed.
Yes, sir. On April 3rd, 2022, officers responded to a 911 call to the location of 925 Canterbury Road in Atlanta. The call specifically said it was a dispute with a weapon. While officers were en route, 911 advised that there was a shots fired called, possibly related to the dispute with weapons called. And when officers arrived on scene, they spoke with the victim, Ebony Droke. The last name is D like dog, R-O-K-E. And she stated to officers that she was assaulted and shot at by her girlfriend, the defendant, whom she lives with. She reported that she and the defendant got into a verbal argument, which escalated, and that the defendant began punching her and choking her. Officers observed lacerations and scratches on Ms. Droke's neck. The officers were then given permission to search the location by Ms. Droke, and they saw in plain view a .22 caliber pistol on the balcony of the home. They also saw damage to the window, which appeared to be the result of a projectile. Ms. Droke then changed her story about the gun and went on to say that the defendant did not shoot at her and denied knowing who the gun belonged to. She also denied the strangulation to our victim witness advocate, and our victim witness advocate was able to speak with Ms. Droke this morning. She asked her to participate in a strangulation assessment and she wasn't able to complete it. Excuse me, I apologize. All right. Our recommendation in this case, Your Honor, is a $6,000 surety bond, no further contact with the victim, stay away from the incident location, a one-day anger awareness course, no alcohol, drugs, or weapons. As pretrial noted, there is a more recent arrest for battery in Doraville. It's a different victim out of Doraville. But our primary concern here, Your Honor, is that the defendant is a convicted felon. There was a gun found at the home. There was an initial claim that she was shooting at our victim. And as a convicted felon, there should be no guns in the possession of the defendant. And even though Ms. Droke did recant, she cannot deny what the officers observed, the lacerations to her neck. And then she still made 2 911 calls about this incident. It was the initial call to get the officers on scene and then the follow-up call about shots fired. So that is why, that's the basis of our bond recommendations in this case. Nothing further from the state.
I'm sorry, Ms. Hartman, I must have missed something. You say she's a convicted felon?
She's not.
I'm sorry, on the GCIC, I saw a 2017 VGCSA out of Gwinnett. She got a felony sentence on that.
Yeah, it threw me off because it said dismissed. But under that, it does say probation 3 years for cocaine.
Yep.
Okay, so she does have a conviction.
Yes.
And I take it, Mr. Howard, that you're taking back the that she can go through pretrial?
No.
Okay, all right. Mr. Ford?
Thank you, Your Honor. First of all, there has not been any evidence that's been presented that connects my client, Miss Wilson, with the gun. So at this point, matter of fact, there's more things to say she didn't have it. She's been recommended by pretrial services to have an unsecured judicial release. If you note her criminal history, there is no violent crimes in her criminal history. My client is a high school graduate. She's 35 years old. She has some college. She is gainfully employed at the Blues Seafood House as a mixologist, or that's a bartender. She's been gainfully employed there. She's also received a scholarship where she is going to be actually going to get her real estate license with the scholarship that she has received. As mentioned, the last case that in Doraville was dismissed, so that should not have any bearing on Ms. Wilson at all. She has a solid address, telephone number, email address. She's been in Georgia all her life. She's not at risk of flight. She's here to deal with these alleged accusations, which she has denied totally. She also has stated that she has a valid driver's license. She has seen no issues that would pertain to any violence in her character or background, and she denies all the allegations that have been made. We feel that a signature bond has been recommended by pretrial services, and we don't, the amount of it, Your Honor, is not an issue with us. We just feel that she should be out to go back to work at this time, and to accept her scholarship to go on and receive her real estate license.
All right. It's going to be a $5,000 signature bond through pretrial, 1-day anger awareness, no further contact with Ms. Droke, stay away from the 925 Canterbury Road address. She can go back to that address on one occasion with law enforcement to retrieve any belongings that she may have there. No drugs, alcohol, or weapons while out on bond. Good luck to you, Ms. Williams. Ms. Wilson, excuse me.
Hello.
Ms. Gant, can you hear us now?
Judge, excuse me, apparently somebody's on the iPhone trying to speak. I don't know who it is. I asked them several times to identify themselves, but I think they're here for the case you just talked about.
Yes, sorry, I am. My name is Ebony Drake.
Okay, Ms. Drake, did you have something that you wanted to say in this regard?
Yes, I did.
Okay, all right, so hold on. Raise your right hand for me.
Okay.
Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, I
do. Penalty of perjury?
Yes.
Okay, you can put your hand down. What would you like to tell the court?
Okay, so I mean, you kind of already cleared everything, but I just kind of wanted to say, like, that day was like a stressful day for her, and we just kind of had like a bad moment. It was her dad's birthday for his passing, and it was alcohol had got involved. It was a little late. As far as the gun was concerned, she didn't know that the gun was here. I was actually trying to put the gun on the counter, so that way, like because I knew the police were gonna come because I had called them. I really just kind of wanted to like take a break. I didn't want her to go to jail. They asked me, obviously they had observed a couple scratches around my neck. And then that was the case of when they decided to bring her in. But, she never did anything with the gun. Out after the first call, like I was trying to get rid of it. Like she never knew that the gun was here. So that had like nothing.
Why would you tell the police that she shot the gun at you?
No, I never said that she shot at me. I never said that she shot at me. But I know, because when it accidentally went off when I was trying to put it up, so that was pretty much it. But she was nowhere around me. She was in the room at the time after the first altercation that already happened. So I just went to go put it up out of the way because I didn't want anybody to, find it. I didn't give the officers permission to come in and to search or whatever. So I guess they just kind of did whatever they, which there's nothing wrong with it. But yeah, so it was just it was her dad's passing. It was obviously alcohol involved. We do live together and we also work together. I think that this is just kind of like one of those days where we just had alcohol involved, and we were actually going to stop drinking that after her dad's birthday celebration. So I wanted to make sure that I did say all of that. Yes, they asked me and they saw the scratches and cuts on my neck. But I couldn't, like do anything from that point. Yeah, like I love her. We don't fight like this. And I think it was just like a bad thing to where I didn't want her to go to jail. I just kind of wanted her to, like walk out. Like I said, we worked together, we lived together. I was able to help her, like, with the scholarship thing. So it's not like a lot of turmoil.
All right. Thank you, Ms. Brooke. My ruling is going to stand. I think there needs to be certainly be a cooling off period. As such, you ought to have no contact with each other. She can come back there one time to retrieve any belongings that she may have there. If you violate this order, then she will be back in jail under a $5,000 bond. Okay, just know that.
Okay, so is she gonna be able to get released, or is it? I don't understand.
She's going to be able to get released, but she's not going to be able to have any contact with you. And she's not going to be. She can come back to that location on one occasion to collect her belongings with law enforcement. Okay.
All right. So it's a signature bond.
Say it again.
The signature bond.
Yes, ma'am.
Okay. All right. Perfect.
All right. Have a good afternoon. Thank you. Let's see, Ms. Gant. All right, so I take it we're going to continue to work with Ms. Gant. Maybe Ms. Gant can call in if that's possible, Ms. Lewis. Yeah, we still can't hear you, Ms. Gant.
It could be a feature on her phone that she's not accepting in order for her to get an audio. She may want to check her settings.
Okay, who do we have in courtroom 2?
Position number 9, judges next, please.
What's the name again, Your Honor?
Okay, very good. Thank you.
It should be Mr. Tom Ford, client.
Okay, Mr. Cohn, is that correct?
Yes, sir.
Good afternoon. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. You have been charged in case 22 CR 002034Y with a hit and run and false report of a crime. Is there a history, Mr. Howard?
Yeah, first arrest.
All right. Mr. Segura?
The incident occurred on January 21st, 2022, and it was in 2 locations. The first was at 400 NB Glenridge Connection, Sandy Springs, and the second was on 7945 Highland Bluff, Sandy Springs. These 2 charges both connected. For the first one, it occurred on around 3 a.m. when the defendant operated a vehicle which was involved in an accident with another vehicle. The defendant did not stop, did not remain at the scene to provide information, and did not render assistance to the damaged vehicle of the other driver. And police were able to identify the extensive damage to the defendant's vehicle. And as of the second charge, it was the exact same day, but this time was at 12 p.m. In this instance, the defendant filed a police report detailing that his vehicle, which was in the accident before, was stolen. Because of this, we're asking for a $3,000 surety bond, $2,000 for the hit and run, and $1,000 for the false report of crime. No alcohol, drugs, and no alcohol, drugs, and weapons. Allegations based on these facts. Thank you.
Ford?
We turned Mr. Cohn in yesterday. He's got 0 prior arrest history. He's had to retain me. That wasn't inexpensive. I would ask for a UJR bond respectfully. I don't know that there needs to be a condition of no alcohol, respectfully.
Anything further, counsel?
No.
No.
All right, it's going to be a $1,000 SOB through the jail for each count, which is a $2,000 signature bond through the jail, and no drugs or alcohol while out on bond. All right.
Is the return date 4/19, Your Honor?
No, that's not. That's for if he were in custody, he will get notification of his next hearing date.
Understood, Your Honor.
All
that
right.
concludes my business. May I be excused?
Yes, have a good day. And Mr.
Thank you,
Cohn,
sir.
good luck to you. Thank you. Who do we have next?
Position number 15, Mr. Robinson, please.
Is this your case? Mr. Good morning, Mr. Robinson. Good afternoon, Mr. Robinson. This is your case, Mr. Ford?
Yes, it is, Your Honor.
Okay. Mr. Robinson, I'm Judge Eric Moore. This is the state court expedited accusation calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Robinson, you've been charged in case 22 CR 002035E with criminal attempt to commit a misdemeanor and criminal trespass and damage to property. Is there a history, Mr. Howard?
Second arrest, 2004, Frey. It was NOD.
Okay. Mr. Segura?
The incident occurred on April the 4th, 2022 at Edgewood Avenue, Atlanta. In this situation, officers witnessed the defendant hitting a bike lock with a hammer and attempting to take it off the bike rack. And the defendant was forcefully pulling on the bike to get it. When police approached the defendant, they told him to drop the hammer he had. And initially he lied and said the bike belonged to him, but officers were able to ascertain that the bike actually belonged to someone connected with GSU. Because of this, we're asking for a $3,000 signature bond, $2,000 for the attempt, and $1,000 for criminal trespass, narco, drugs, and weapons, and stay away from the Edgewood Avenue. Thank you.
Want to stay away from all of Edgewood Avenue?
Yeah, the incident report is not really specifying as to what part of the Edgewood Avenue the bike was attempted to be stolen from. So the state feels more safe just to stay away from the general area.
All right, Mr. Ford?
Did I hear $3,000 signature bond, Your Honor?
Yes, signature.
Signature, Mr. Segura? Okay. We concur with the signature bond, Your Honor, and have no statements at this point.
All right. He doesn't live on Edgewood Avenue, does he? I mean, I don't want to keep him away from his
No,
home.
he doesn't, Your Honor. Is there any way that we can specify maybe the section at Georgia State University or something of that nature?
Was this at Georgia State?
How about we could modify to stay away from the Georgia State property of that Edgewood area?
Okay, I think that's reasonable. Ms. Bridgewater, you got that?
Stay away from the Georgia State what?
The Edgewood Avenue location at Georgia State.
Gotcha.
All right, and it's going to be a $2,000 for the criminal attempt, $2,000 SOB through the jail. For the criminal trespass, $1,000 SOB through the jail. Stay away from the Edgewood Avenue location. No drugs, alcohol, or weapons while out on bond.
Okay, Judge, how much on the criminal attempt? That 1,000 or 2,000?
It's 2,000 on the criminal attempt, 1,000 on the
1,000.
criminal trespass.
Okay. Thank you.
You're welcome. Good luck to you, Mr. Robinson.
Got signature bond, sorry.
King, move from in front of the doorbell.
Jenny O. Okay.
Position number 14, Mr. Ragland, next, please.
Your Honor, Ragland was one of our requests for breakout.
Okay. And do we have another request for breakout? I'm sorry.
We do, but it is, let me see, it's position 2, which I believe is a Miss Gant case.
Okay.
It's on right now.
Say it again, Ms. Lewis. Did you say something?
Yeah, Miss Gant is on the line now.
Oh, okay.
Bring up her video or not. There she goes.
You hear me?
Yes.
Oh, okay. Yes, Ms. Gant.
All right, thank you.
All right. So since we're going to go into a breakout, let's go into a breakout for position number 2 and for position number 14. Okay. So Ms. Falk, Ms. Gant, Mr. Ford.
It's also going to be Miss Harmon and Miss Sawari.
Okay.
Which position is 2?
Ms. O'Neill, Ms. Jenny O'Neill, can you please unmute yourself?
Yes.
The courts are consistent, want you in the breakout room. I'm getting ready to send you a request and you're gonna have to accept the request to go in there, okay?
Okay. Where will the request come, in this
You
room?
may have to look on the meet more, look like you're on a phone, so you may have to select more and it should pop up.
Okay.
Give me a second. The request should be there. Ms. Sonia, I'm gonna stop your video for temporary since we're in the breakout room right now, okay?
Okay, so we've had a discussion. This is Mr. Ragland. Mr. Ragland, we've had a discussion with your counsel. Your mother joined us, and the state. It's going to be a $3,000 signature bond through pretrial. We're gonna have a social worker visit you so that we can get you established at Gateway. You're to have no further contact with your mother, Jennifer O'Neill, nor with Kashawn Bell, your brother. You're to stay away from the 2794 Nerone Court, Southwest Atlanta address. You can go back to that address on one occasion with law enforcement to retrieve any belongings that you may have there. No drugs, no alcohol or weapons while you're out on bond. All right.
Who was this?
This is position 14, Mr. Ragland.
What was that bond?
$3,000 signature bond through pretrial.
Can I speak?
Okay?
May I say something?
Mr. Ragland, you have a right to remain silent. Anything you say can be used against you. Mr. Ford, do you want to?
No, I'm going to ask Mr. Ragland not to say anything. Mr. Ragland, your case has been decided. You're going to get a signature bond and you'll be released today. Not today, after you get the social worker visit to get you lodged at Gateway, okay? So I would ask that you not say anything at this time. Okay?
All right. Courtroom 2.
Judge, can we go back to Union City now, please?
We can, but I just want to make an announcement. Do we have Mr. Alvarez in your court?
Give me one moment, sir. I'll pull him out.
Okay, if we haven't, we already have the decision on him too. We did that while we were in the breakout room, so we can get through
Address him. Okay, I'll pull him out, Judge.
Okay, thank you.
This is position number 2.
Okay, thank you. Good afternoon, Mr. Alvarez. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we are holding by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes.
Thank you. Mr. Alvarez, you've been charged in case number 22 CR 002040G with pedestrian under the influence. We've had a discussion regarding your case with your counsel and with the solicitor's office. You've been granted a $3,000 signature bond through pretrial services. You're going to receive a social worker visit to help hopefully get you into the Gateway program. You to stay away from 460 Kinderman Point. You can go back to that address on one occasion with law enforcement to retrieve any belongings that you may have there. You also to have no further contact with your mother, Karen Carter. And you to have no drugs, alcohol, or weapons while you're out on bond. Okay? All right.
This is per judge.
Say it again.
This is per judge.
I had Mr. Alvarez as a pretrial.
You did?
I believe I did.
He is, Your Honor. He was recommended.
He was recommended for a signature bond for not necessarily pretrial. It's either pretrial or jail. But no, he should have been jail.
All right, well, per judge. Good luck to you, Mr. Alvarez.
Thank you.
All right, let's go back to the South Annex now.
Yes, Your Honor, position number 6.
We did, Evans.
Yeah, I think that, is this Miss Evans?
Yes, sir.
Yes,
Okay,
Your Honor.
I think we completed.
Oh, sorry, I hate to interrupt. Ms. Gant did not have an opportunity to present her side. I presented my version of the events. Ms. Gant did not have a chance to respond.
Okay, so why don't we do this, Ms. Falk, since Ms. Gant wasn't present, would you mind representing?
Sure. Let's go back. Let me see. All right. Yes, Your Honor. This case involved the victim, Mr. Anthony Artister, and the defendant. The two of them were at the location of 100 Lakewood Way, Southwest Atlanta, Georgia. yesterday on April 4th. A first responder who was at the location actually observed the defendant chasing Mr. Artister and throwing rocks at him while their 6-year-old child was left in Mr. Artister's vehicle. When they spoke with the defendant, she stated that she and Mr. Artister were in a verbal dispute, which escalated, that they then drove to the incident location from Mr. Artister's place of work, at which point another dispute ensued and she sprayed pepper spray at Mr. Artister. She did admit to the officers that at no time did Mr. Artister hurt or physically put his hands on her. Mr. Artister then told the officers essentially the same thing, that the defendant showed up at his job on Moreland Avenue. An argument took place. They drove to the incident location. A verbal argument ensued at that time. Mr. Artister does have custody of the child. The state is recommending a $1,000 surety bond, no further contact with the victim, Anthony Artister. We're also asking for a stay away from Mr. Artister's place of employment and his residence, as well as 1-day anger awareness and no alcohol, drugs, or weapons. Again, as I pointed out before, what is of particular note is not only Ms. Artister's the defendant's admission to spraying pepper spray, and that Mr. Artister never physically harmed her or never posed a physical threat to her, but also the fact that there was a third party, not a law enforcement officer, I believe it was a first responder who was actually at the scene, an officer from the fire department who was at the scene, who observed the defendant running and chasing Mr. Artister and throwing rocks at him. So for those reasons, that is our recommendation.
Okay, thank you. Ms. Gant?
Your Honor, I believe that I do apologize for being late to join the Zoom call, but I did not hear my client's criminal history from.
Okay, that's fine, Ms. Gant. I'm happy to accommodate. And I believe that she's recommended also.
Yes, Your Honor.
Mr. Howard?
I can help fill that in as well, Your Honor. There's a previous 2009 giving false information to law enforcement officers that was null prost. But
Okay.
again, our concern, the reason for the surety bond is not only the activities as well as her following him, going to his place of work, but also that the lack of cooling off period. And the fact a child was also there in the vehicle when all of this happened.
Ms. Gant, anything, other information that you need before you go forward?
I'm able to go forward. Thank you.
Okay.
Thank you. Ms. Gabrielle Evans is 32 years old. She has been in the Atlanta, Georgia her entire life. She has 6 children, 2 of which she shares with Mr. Artister, a 4-year-old and a 4-year-old and a 1-year-old. She also has 4 other children ages 15, 12, 10, and 5. She informs me that she, in fact, is the primary caretaker and that she is not receiving any child support. Ms. Evans she went up to the 12th grade but did not graduate. She has been unemployed for the past 3 months. However, she is looking for work. Prior to becoming unemployed, she was employed at the airport for MSL car rental services. She denies the allegations, Your Honor. She states that what she recalls about this incident is that Mr. Artister in fact chased her while she was holding her son. She fainted and then she woke up to police and the fire department on site. Your Honor, I did have the occasion to speak to Mr. Artister. He states that he is not afraid of Ms. Evans. They do not live together. However, I am opposed to any stay away conditions at his place of employment and at his residence. And I would ask that your Honor grant a no violent contact order. And again, we are requesting a signature bond, Your Honor. Thank you.
So they don't live together?
They do not live together, Your Honor.
Okay. And does she have, I'm sorry, excuse me, does she have custody of the 2 children that they have together, or the 4 and the 1-year-old? Is that right?
She informed me that she has custody of all of her children, including the 2 that she shares with Mr. Artister.
Okay.
Artister.
Anything further, counsel?
Nothing further from the defense, Your Honor.
the only thing the state would say is obviously the version of events that was just given vastly contradicts what was witnessed by a third party and reported to police. And I would just argue that the third party who does not know either of these two parties and saw the defendant chasing down this victim would probably be the more credible party.
And Your Honor, I would add at this stage, we are addressing bond and not guilt or innocence. And I basically articulated my client's ties to the community. She does not have any convictions of violence. And I am again renewing my request for the signature bond. Thank you.
Okay. And I'm going to grant her a signature bond, Ms. Gant. My biggest concern was Mr. Artister, given that you've told the court that you've spoken with him. It's going to be a $2,000 signature bond through pretrial, one-day anger awareness, no further violent contact with Mr. Artister, no drugs, alcohol, or weapons while out on bond.
And Your Honor, I'm not sure if the court recalls in my presentation the first time, we had also spoken to Mr. Artister, who again stated he doesn't remember any of the events, doesn't remember being chased, doesn't remember her throwing rocks, and doesn't remember pepper spray, which again contradicts everything in the report, which is why we had concerns about contact.
Well, I mean, she doesn't not have much of a record. She's recommended through pretrial, and she has a number of obligations that she needs to deal with. And I'm going to allow her to deal with those 5 children, those 6 children that she has a responsibility for. Thank you. Who do we have next?
Thank you.
Position number 7.
Ms. Hughley?
Yes, sir.
Good afternoon, Ms. Hughley. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes.
Thank you. Ms. Hughley, you've been charged in case 22 CR 002036G with obstruction of a law enforcement officer and simple battery against a police officer or detention officer. Is there a history, Mr. Howard?
The second arrest. Last was September 2021. Battery on a school teacher or other school personnel loitering upon school premises or within the school safety zone and simple battery. That's a $10,000 pretrial bond.
Okay. Sorry.
Yes, Your Honor. In this case, officers responded to 3144 Martin Luther King Drive in Atlanta regarding a physical dispute. The dispute was between the victim and her grandmother, Barbara Wallace. The officer noticed when he arrived that the defendant was running up the stairs, screaming and trying to get inside her grandmother's home. The officer then saw the defendant go towards her grandmother in an aggressive manner. And when he tried to stop her, she pushed his arm and told him not to touch her. The defendant then threw AirPods at the officer's direction. As we've heard from pretrial, Your Honor, this defendant does have a 2021 battery on a school teacher, which does show that she presents a danger to the community. She did receive, according to pretrial, she received a pretrial bond on that one. So we will be filing a motion to revoke. In this case, Your Honor, the state recommends a $1,500 surety bond on each charge with conditions of staying away from the incident location, no contact with Ms. Barbara Wallace, a one-day anger awareness class, and no drugs, alcohol, or weapons while on bond. Nothing further.
Ms. Gant?
Thank you, Your Honor. Ms. Nidrika Hughley is 18 years old. She has been in the Atlanta area her entire life. She has family here, including her mother, and her grandmother. Your Honor, we are unopposed to the stay away at 3144. We are also unopposed to the no contact order, as Ms. Hughley informs me that she does not wish to have contact with her grandmother at this time. Ms. Hughley is in high school. She attends Hank Aaron High School. She makes A's and B's. She is on track to graduate this spring. She wants to study or enroll in college to ultimately become a pediatrician. She is unemployed at this time, Your Honor. Therefore, she does not have the means to make bond. And of course, she is 18 years old. I reached out to her mother, Miss Santana Hughley, regarding bond for today. And of course, we do have the issue with the possible revocation of the $10,000 signature bond. Your Honor, she has an open case. However, she is presumed innocent in that case, in this case as well. In fact, she denies the allegation. She states that she is pregnant. The officer on scene was becoming very aggressive with her and screaming at her and placing her hands all over her body, and that she felt threatened. With regard to the state's contention that my client is a danger to the community, I would again bring to the court's attention that she is 18 years old and she does not have any prior convictions. It is for these reasons, Your Honor, I'm requesting a signature bond, and if Your Honor determines that she is ineligible, then the lowest bond possible, considering that she is unable to pay bond, and I have not been able to confirm with her mother how much she's able to contribute to bond in light of that possible bond revocation. Thank you, Your Honor.
And Your Honor, we just want to reiterate the 2021 battery on a school teacher that's open, where she received a pretrial bond. So she was given a chance to sign herself, and she has violated her bond conditions by obtaining this charge. And we would also like to include the condition that she completes high school. Nothing further.
All right, so it's going to be a $500 good bond for each charge, making it a $1,000 good bond. Is it 3411 or 3144?
3144.
Okay, so stay away from 3144 MLK Drive. No further contact with Barbara Wallace. No drugs, alcohol, or weapons while out on bond. Good luck to you, Ms. Hughley.
That'll be all for South Annex, Your Honor.
Okay, thank you so much. We'll see you
Thank
next
you
time.
again. Yes, sir.
Who do we have next?
Position number 8, Mr. Johnson, please.
Good afternoon, Mr. Johnson. I'm Judge Eric Morrow. This is the state expedited accusation calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Johnson, you've been charged in case 22 CR 002037E with driving while license suspended or revoked. Is there a history, Mr. Howard?
16 total. Last arrest was back in June. Misdemeanor possession of marijuana, possession of a firearm by a convicted felon or felony first offender. 2016 sale of marijuana, 2 counts. Crossing state county guard lines with drugs, weapons. That was a conviction. 2016 suspended license conviction. 2015 fleeing an officer, suspended license. Misdemeanor possession of marijuana conviction. 2014 bail jumping conviction. 2014 suspended license conviction. You got some probation violations in this history too.
So is that 4 suspended license convictions?
I didn't count them. Hold on. 1, 2, 3. Well, the 2014 he pled no-lo. So I think it's 2 convictions, 1 no-lo. Yeah, something like that.
Your Honor, I will say it didn't meet the criteria for felony transfer because they weren't 4 within 5 years.
All right, thank you, Ms. Falk. Ms. Sari?
Yes, Your Honor. In this case, an officer was traveling southbound on Fulton Industrial Boulevard, Northwest, when he observed a car driven by the defendant at a high rate of speed. The officer initiated a stop and the defendant then exited the vehicle. The officer gave verbal commands for the defendant to get back into his vehicle, which he did. And the officer asked for the defendant's license, his driver's license, which the defendant stated he did not have one. And when the defendant's name was read, it showed the defendant's license was suspended back in 2015. He had a previous driving while license suspended, FTA, child support obligations, and he was wanted out of Cobb County for child abandonment. Your Honor, as we've heard from pretrial, this defendant does have a history of driving offenses. A 2014 no-low driving while license suspended, 2009. He does have multiple probation violations. He also has a bail jumping and leaving the state guilty conviction. So the state is concerned of this defendant reoffending as well as not appearing to answer to these charges. The state's recommendation is a $3,000 surety bond with conditions already of no driving and no drugs, alcohol, or weapons while on bond. Nothing further.
Thank you, Ms. Gant.
Thank you, Your Honor. Mr. Ara Johnson is 36 years old. He has been in the Atlanta area his entire life. He has family in the area, including 4 children. He is obligated to pay child support for those children. And as we see that he has that Cobb County hold because of issues making child support payments, Your Honor, his children are ages 13, 9, 8, and 3. Mr. Johnson obtained a GED. He is unemployed at this time, Your Honor. Well, let me back up, Your Honor. He states that he was arrested while at work at the Great American Cookie Factory, and he is not sure whether or not he will be able to continue in that job once he returns. He was in that position for 7 months prior to being arrested. Your Honor, I would ask for a signature bond in this case. I acknowledge my client's history. However, the last driving offense that I heard was back in 2016, well over 6 years ago. He has a hold. I'm asking again for that signature bond so that he can deal with that to take care of his child support situation, Your Honor. And of course, he was cooperative with the officers, and we do not object to any conditions regarding no drugs, alcohol, or weapons. Thank you, Your Honor.
Okay, it's gonna be a $5,000 signature bond through the jail, no driving, no drugs, alcohol, weapons while out on bond. Good luck to you, Mr. Johnson.
Thank you, Your Honor.
Position number 10 is Mr. Liggett.
Your Honor, regarding Mr. Liger, the state offered a plea and he is willing to accept that. I discussed his rights and he will be proceeding pro se.
What's the offer?
Time served.
And how much time served?
1 day is currently what he has served. So 1 day jail, credit for time served, release for time served.
Okay.
And I do have paperwork. I'm just not sure where to send it.
Is there a history?
There is, Your Honor. I can either give you that history or pretrial can.
Can you give it to me, Ms. Falk, if you're there, if you have it?
I do.
Okay,
Let me pull that up. So his history is, he does have some drug history, Your Honor, just to let the court know. Particularly the defendant has a 2021, and let me just scroll down. He has a current open 2021 possession of methamphetamine. I believe that has been resolved subsequently. I did see the 21 SC case and I can pull that up and give you his sentence on that. He has a giving false name in 2020 from Cobb County. He also has we're showing a possession of marijuana. However, I am not showing a result on that case in Douglas County State Court. He has a probation violation from 2019 in Clayton County State Court, a driving without a valid license, giving false name in 2019 from East Point. He also has some failure to appears on his history in 2018 in Clayton County, and entering an automobile where he received 2 years probation, March 12th of 2018 in Clayton County. Going further back, he has a theft by shoplifting where he received 12 months probation in 2019 in Clayton County. We're also showing a charge that I would need to put in the chat, but that charge is back in 2017 and is not drug related. So that is his prior history. As far as the 2021 SC case for possession of methamphetamine and drug-related objects, he did enter a guilty plea in that case, and his disposition was, I can just pull that up really quickly.
12 months probation.
12 months probation.
February.
That is correct. As of February 3rd, 2022.
And he has the FTA one out of Gwinnett.
Okay, so does he, thank you, Ms. Falk and Mr.
Sure.
Howard. Does he have a bond on this already?
Actually, he has a $1,000 surety bond on this case, Your Honor.
Okay. Good afternoon, Mr. Live. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar. We're conducting this calendar today by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you, Mr. Liger. You've been charged in case 22 CR 002029Y with possession of marijuana less than an ounce. Let me tell you from the get-go that you have the right to remain silent. Anything you say can and will be used against you. You have a right to have an attorney present at these proceedings. We have offered you the assistance of a public defender today, and it's my understanding that you wish to proceed without the assistance of counsel regarding this possession of marijuana less than an ounce charge, and that you are seeking to plead guilty to it. You must also know that if you plead guilty to this charge, that if you are currently on probation, that your probation can be revoked because of your guilty plea here. You also need to know that you will always have a guilty plea on your record for possession of marijuana less than an ounce. Given all that, and you do have the right for if you want to seek counsel to argue your bond today, that you have a right for Ms. Gant to argue regarding reduction of your bond today. Given all that, what is it that you'd like to do, Mr. Liger?
I'm a victim, currently disabled and unemployed.
Mr. Liger, I'm sorry, I can't understand you.
Can you hear me better now, sir?
Yes, very good, thank you.
I'm a gunshot victim with nerve damage to my left brachial plexus. Right here, it should be my paperwork. So I self-medicate. I was at East Point train station heading home.
Okay, hold on, Mr. Liger. I don't want you to tell me any of the facts, because you have a right to remain silent in this matter. Okay. What
I'm trying to gain clarification on right now is that I agreed to enter into the plea and not have counsel based on the time served. But if that is going to be something different offered for me today, then I would like to have my attorney present.
Okay, so I believe Ms. Ginn is not going to represent you with a plea, given that she doesn't feel comfortable just not having a chance to get into the real facts of your case and to properly represent you. So I believe, if I'm not mistaken, that's why Ms. Ginn is going to have you proceed pro se today. Is that correct, Ms. Ginn?
That is correct, Your Honor.
Okay, and what I was saying to you, Mr. Liger, is that as part of the recitation that of the rights that you're going to be given up if you plead guilty, you also must know that if you're on probation, which you are on, that could affect that probation. Okay. And You also have the option, if you want Ms. Gant to argue for bond in your case, where she can properly look into your case. You would have the option, if bond is granted to you, to come back at a later time regarding this matter.
Yes, sir.
Okay. So given all that I've said to you, what would you like for us to do today?
As far as today, I would like to plead guilty. I'm not really concerned about the contradiction with my probation because I've already discussed that with them. So we have an understanding, but I need to handle my stuff with Lynette so I can get back. Because I have therapy for my arm and stuff like that, and I can't get the treatment I need while I'm incarcerated. So I'm trying to hurry to get my business and my affairs handled so I can get back.
Okay, I understand that, Mr. Liger. I can't tell you what to do. That's not my job to tell you what to do. But what I'm stressing to you, and I don't understand if you understand what I'm saying, but you have a right for Ms. Gant to argue for you to get a reduction in your bond.
Today.
Understand, to where you might be able to get out and go deal with what you need to deal with, and then come back and deal with this matter.
I'm understanding that, but you're saying that would be at a later date.
We would do a bond hearing. That's what this is. This is a hearing on bonds today. So we would do that today, right now.
Okay, so then can we do that?
If that's what you want to do. I'm not, I'm just trying to make sure that I know that you understand what your options are.
And then come back on the next call. So can I have one-on-one with my attorney before we proceed with anything else? Because
Yes, I can have you talk to Ms. Gant and discuss your case with her right now if you want us to do that.
All right.
Is that what you want?
Yes, sir.
All right. So, Ms. Gant, if you would call the jail and speak with Mr. Liger regarding this matter, the court would appreciate it.
Yes, Your Honor. Thank you.
Okay.
Do we have any? Just so that I have said this for the record, the plea offers for today only, so it will be withdrawn after today.
Okay, thank you, Ms. Falk. Let's see, do we have anyone in courtroom 2 that would be Mr. Ford's client?
Judge, we're gonna position number 13, Mr. Outlaw, please.
Is this your case, Mr. Ford?
Yes, it is, Your Honor, and I apologize. I had to switch devices due to the fact that my other one froze. So I'm glad I'm back with you.
Okay, we're glad you're back too. Good afternoon, Mr. Outlaw. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, Your Honor.
Thank you. Mr. Outlaw, you've been charged in case 22 CR 002027E with battery family violence. Is there a history, Mr. Howard?
A 25 adult arrest. Got history out of Pennsylvania and Delaware. Last arrest was 2020 for speeding in excess of posted limit out of Delaware. It says 2009 burglary conviction. I don't think I saw any adult violence. Hold on. So weird history. Yeah, the 2019 assault that was dismissed. It was Nara Prost out of Delaware, family court. He got a lot of traffic stuff and criminal mischief and yeah, theft by unlawful taking and criminal trespass, theft by receiving. But he wasn't recommended because he's 35 with 25 adult arrests. So it was extensive history, but nothing further.
Okay. Mr. Segura?
The incident occurred on April the 4th, 2021 at the instant location at 3108 Garden Walk, Atlanta. Please were called to the location by Ms. Raynisha Tebe. Raynisha spelled Tibby, spelled Tibby, to 911. When the police met Miss Tibby, they noticed that she had bruising and swelling to her left cheek, just right under her eye. When questioned, she said the defendant punched her right in the face, which resulted in the swelling and bruising. At that point, Ms. Tibby told the officers that she was visibly shaken and she was deeply afraid. And the main thing that caused the defendant to attack her was when she asked him to leave the location and to return the house keys. When the police met the defendant said he did not hit Ms. Tibby, and in fact, she actually hit herself, which we find a bit off, since it seems extreme she able to hit herself and cause that much damage. The state is recommending a $5,000 surety bond, no alcohol, drugs, and weapons, 1-day anger awareness, a stay away from 3108 Garden Walk, Atlanta, and no further contact with Renisha Tibby. Allegations are based on facts, as well as because we want to make the court known that Ms. Tibby is in relationship with the defendant and they both reside in the same home. Alongside, Ms. Tibby told the officer that there are 14 children living currently at the home, ranging from diaper age to the oldest at 16. And we're deeply concerned because if the defendant is allowed out and to visit, we're concerned that children could witness acts of violence. And also, we'd like to make it known that this incident occurred only yesterday, so there's a very low cooling off period. Alongside, we'd like to make it known that the defendant has a long prior history, and the most recent was in 2020 in Delaware. Because of this, we noticed that there's very few significant ties the defendant has to Georgia. So we're deeply concerned that if he's let out, he will simply escape. Again, since he doesn't seem to have very few and weak ties to Georgia. Thank you, Your Honor.
Have you spoken with Ms. Tibby, Mr. Segura, or your office?
We weren't able to make a connection.
Okay, thank you, Mr. Ford.
Your Honor, I did talk to her.
Okay.
And she wants to have contact with Mr. Outlaw. You know, it's amazing when they said the last, arrest was in 2020. Your Honor, that last arrest was for speeding in excess of the posted limit. Your Honor, that could have been 1 mile over, 2 miles over, but he was speeding, Your Honor. He's also been recommended by pretrial services for an unsecured judicial release. Mr. Outlaw is 35 years old. He has an associate's degree in business management from Ohio U. And I mention that because right now he is the administrator for Key Home Care Services, where they take care of seniors and also perform services as far as hospice and those types of things. Mr. Outlaw is not going to qualify for our services, Your Honor, after today, due to the fact that of his extensive salary. At this time, but his extensive salary is there to support the fact that he has 8 children, Your Honor, 8. And I take that back. He may qualify for our services with 8 children. If I look at the scale, 5 of those children, I believe at least 4 are with Miss Tibby. They live in the same household. They are raising these 8 children. There were some issues with the facts. The ASG wants you to believe that there's no way she could have hurt herself. My client is very adamant that he is innocent of these charges. He's not at risk of flight. They've also talked about he has some issues in Delaware. My client has a job making substantial money. He has 8 children here. The person he put down as the person who we could contact, that's a close relative or friend, was his sister, who's here. I take that back. He gave me the telephone number. I'm not quite sure he's here, but he has tremendous support. He moved here 18 months ago because of the job. So he's not flying. He's not at risk of flight of anywhere, to go anywhere, Your Honor. And I also want to read a portion of the pretrial services report that says, based on the defendant's criminal history, the defendant does not appear to be a flight risk or a danger to the community. The defendant is recommended for unsecured judicial release. This is a person that has tons of ties here. He's here to prove his innocence, Your Honor. we feel that the recommendation of an unsecured judicial release is appropriate. I did talk to Ms. Tibby, and I thought that she was going to be on the line, but I did have an opportunity to speak with her. She needs help with the 8 children that are at the home. He has the dependents of 3 because 3 of his are his children, and the rest, I believe, are by Ms. Tibby. I have a secure telephone number for him, email address. Your Honor, this is a person who wants to definitely be around to prove his innocence because this job depends on it. He cannot have a charge like this on his record. So at this point, Your Honor, we're asking for a signature bond. It doesn't matter the amount, Your Honor, but this person should be able to get out, take care of his children, and preserve his job.
All right, it's going to be a $3,000 signature bond through pretrial per the judge. 1-day anger awareness, no further violent contact with Ms. Tibby, no drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Outlaw.
Yes, sir. Thank you, Your Honor.
You're welcome.
Judge, can we go back to
Thank you, Your
position
Honor.
number 10, please?
Okay. Ms. Gant?
Yes, Your Honor. We will proceed with the bond hearing.
All right. Let me just start from the top then.
Your Honor, I was listing.
Okay. For myself, I'm sorry, Ms. Gant, not for you. It's for
I
me.
do apologize.
Okay. Mr. Howard, would you go back over the history for me, please?
Yeah. 13 total. On probation for disorderly conduct, possessing of drug-related objects. That's 21 SC 178484. Last arrest was May 2021. Theft by receiving out of Gwinnett County. He has a FTA warrant out of Gwinnett. Hold on, let's open the theft by receiving. March 2021, possession of meth out of College Park. Well, yeah. 2020, given false name conviction. 2020, sale of marijuana. It was amended to a non-fingerprintable charge. 2019, probation violation, felony out, and misdemeanor probation violation out of Clayton County. 2019, given false name, driving without a valid license. 2018, probation violation, shoplifting out of Riverdale. 2018 FTA shoplifting, disposition was not prosecuted. He got first offender 2017 for entering auto out of Clayton County. A shoplifting conviction, obstruction conviction from 2017. And he had the CWAC charge from 2016? Yeah, out of DeKalb County. That's it.
Ms. Falk?
Your Honor, I just want to say I would be remiss if I did not say this on behalf of the state. One, the state is withdrawing our recommendation. I just wanted to make that clear for the record to the defense. Two, the reason the state made the recommendation is because in the interest of judicial economy, with the fact that we are dealing with an unprecedented backlog of cases, we do feel it is necessary to where we can try to work out cases in a timely fashion and not just kick the can down the road, that it is in the best interest of the judicial system as a whole to try to move these cases as best we can. The state's offer was not unreasonable. In fact, it was quite reasonable. And I do kind of take a little bit of, I am a little frustrated that when the state does try to move these cases in an expeditious manner, where the defendant is saying he does want to enter a plea multiple times, that essentially he's being talked out of his own decision. So I do want to make that clear before we get started.
Okay, so and let me just respond to that particular point, because I want to make sure that everyone that comes before me, no matter who they are, that they understand not only their rights, they understand the ramifications of their decisions. And I want to be clear that I'm comfortable with that they understood that. The reason that I did what I did was because I wanted to make sure. I wasn't sure that he understood the ramifications of what could happen with his probation. I wasn't sure that he understood what his rights, what his rights would be. So I wanted to make sure that I was comfortable with that. Okay, and I understand the PD's the PD's position that they won't represent somebody this early on if they want to take a plea. I mean, that's been an ongoing concern of theirs, but I'm the one that has to be comfortable with what this young man is doing, that he understands. So I'm not trying to talk him in or out of anything. I'm trying to make sure that he has all of the information so that he can make an informed decision about how to go forward. So, so that's what I'm trying to do. And I understand judicial economy, and I also understand, what some other recommendations for this type of charge is down the road. So, that's just my response to that. I'm going to let Ms. Falk continue because I just wanted to respond to that bit.
Could I respond to that, Your Honor?
Your Honor,
seconds.
Mr. Ford isn't the attorney for the defendant.
But you made a generalized statement, and I would like to just, on behalf of the Public Defender's Office, just state that judicial expediency is not what is always in the best interest of a client. That's why we choose to take the position that we do. We want to make sure that justice is being provided to everybody, not just because they can get rid of a case as quickly as they can. And Your Honor, I don't want to step on anything that you've said, but I just want to make sure that the Public Defender's Office is not here for judicial expediency. We're here for the fairness and the justice of our clients.
Okay, so I think that we have all made our positions known on this matter.
I believe so.
Okay, and just so everybody's doing their job. So I understand, Ms. Falk, you're doing your job. Ms. Gant, you're doing your job. And I feel like I have a job to do also, and I'm trying to do my job to the best of my ability also. So with that said, let's get to the matter at hand.
Yes, Your Honor. This happened on April 4th of 2022 at 2848 Main Street. The defendant was at the East Point MARTA station. He was observed by a plainclothes officer who smelled a heavy odor of marijuana coming from the defendant while he was standing on the platform smoking marijuana. At that point, the defendant boarded the northbound train, exited at Garnett Station. He was then detained by the officers. In his possession was a clear bag of a green leafy substance containing marijuana. The amount was 0.28 ounces, which is about a quarter of an ounce. Actually a little over a quarter of an ounce. The defendant's prior history, the pretrial has gone into, as well as the state. Of note is the fact that the defendant is currently on probation and was sentenced February 3rd of 2022. And within 2 months of his sentence, after being put on probation, where he received a downgraded sentence of disorderly conduct from the charges of possession of methamphetamine and possession of drug-related objects, he has now not only violated the terms and conditions of his probation with this charge, but has also shown that he is not, he is a risk of reoffense, being that he had that previous conviction only 2 months ago. Additionally, we also have the other drug charges on his history that pretrial has stated that give the state some cause for concern that he is a risk of reoffense. For those reasons, the state recommends a $2,000 surety bond. The current bond is $1,000 surety bond. We are recommending, based upon his history, a $2,000 surety bond. We are also recommending that he stay away from MARTA stations and have no drugs, alcohol, or weapons as provided. That's all for the state.
Thank you, Ms. Falk. Ms. Gant? You're on mute, Ms. Gant.
I do apologize. Colin Liger is 22 years old. He has been in the Atlanta area since 2014. He has family ties here. Your Honor, Mr. Liger obtained a GED. He also completed a half semester of college. down at a college in North Carolina where he studied music. Your Honor, he is disabled and has been so since 2020. He suffers from chronic pain from a gunshot wound. He has informed me that it is difficult for him to move around in the jail and that he still has a bullet in his leg. Your Honor, on Mr. Liger's behalf, we are denying the allegations. He will come back and defend against these allegations. Your Honor, he does not have the means to pay any bond whatsoever. So despite my client's history, and I'm requesting a signature bond, especially in light of the Gwinnett County hold, he needs to get there so that he can take care of all of his legal matters. And we are opposed to the stay away for all martyrs. We would just ask that that be limited to the 2848 Main Street location. And lastly, I would bring to the court's attention that there is no allegation that Mr. Liger was smoking marijuana. The warrant reads that the officers, despite the fruits of this arrest being found in a plastic bag, the officer could smell strong odor of marijuana, but there is no allegation whatsoever that my client was smoking any marijuana in public.
Well, actually, the warrant does state while he was standing on the platform smoking. So just to clarify, the officer smelled the heavy odor of marijuana while the defendant was on the platform smoking. So I will amend that to say that is what the warrant states. Now, whether it was marijuana or not, the officers made the inference that there was something involving the odor of marijuana, and that justified the stop.
Anything further, Ms. Gant?
Nothing further, Your Honor.
All right, I'm going to release him to the Gwinnett County hold. It's going to be a $5,000 signature bond through the jail. He's to abide by any MARTA imposed restrictions, no drugs, alcohol, or weapons while out on bond. Mr. Liger, I'm going to let you out, but you're going to have to make sure that you come back to answer for these charges. You understand?
Yes, sir.
All right. Good luck to you, sir.
Thank you, sir. Thank you, Ms. Gant.
Thank you, Your Honor.
Who do we have next?
Position number 3, Mr. Blake, please.
Good afternoon, Mr. Blank. I'm Judge Eric Morrow. This is the state court expedited accusation calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video? Can you hear me, Mr. Blank?
Yes.
Okay. You've been charged in case 22 CR 002026G with loitering and prowling and obstruction of a law enforcement officer. Is there a history, Mr. Howard?
This is 5th arrest. Last arrest was on the 14th of March. Sale of marijuana. That's 22 CP 207-450. It's his first Georgia arrest. 2019 out of Tennessee, failure to appear. 2019 reckless endangerment, possessing a firearm with intent to go armed. The endangerment was dismissed. The firearm charge was dismissed. 2019 suspended license. That's it.
I'm sorry.
Yes, Your Honor. In this case, officers responded to 875 Martin Luther King Drive. That's the location of a Chick-fil-A. The officer was patrolling the area due to it being a hot spot for break-ins of vehicles. The defendant was seen at the incident location, squatting down beside a vehicle parked on the street. And when the defendant noticed the officer, he stayed in a crouched position to avoid being seen by the officer. And when the officer turned around to follow the defendant, he took flight. When the officer finally caught up with the defendant, he did find marijuana in his possession. 2 victims approached the officer and stated that their vehicles had been broken into and their windows had been smashed. Initially, Your Honor, we did not have the report, but we will go ahead and add the 2 criminal trespass charges to the defendant's case. But for the loitering and the obstruction, the bond has been set for $1,500 on the loiter and $2,000 on the obstruction. The state would just request that the bond remain as set. with conditions of staying away from the incident location and no drugs, alcohol, or weapons while on bond. Nothing further.
Thank you, Ms. Gant.
Thank you, Your Honor. Mr. Benjamin Blake is 21 years old. He has been in the Atlanta area for the past 2 years. He has family here, including an uncle, a father, and a cousin. We are unopposed to the stay away at 875 MLK Drive. Mr. Blake completed high school and he is self-employed as a photographer. Your Honor, he denies the allegations. He states that he was at that location 875, which is pregame. It's a nightclub. He states that when he saw the police, he noticed that the police had a taser. He felt threatened, and that is the reason why he fled. He also states that when he was brought into the officer's custody, he states that the police took him inside of the establishment and talked to the club owner. The club owner told the police that Mr. Blake was inside at that time taking pictures as he was there on a job when the cars were broken into. And I would also bring to the court's attention that there is no charge whatsoever before this court where he was accused of breaking and entering autos. He states that at that time, my client's belief is that they obtained the suspect who had broken into cars. So for these reasons, Your Honor, I am requesting a signature bond. These are nonviolent offenses. My client offers a competing version. And if Your Honor is not inclined to grant a signature bond, I would request the lowest bond possible, Your Honor, as he is not able to pay much toward bond as working as a photographer has not allowed him to amass a huge amount of wealth. And in fact, he is set to take on a job at JR Crickets this week to supplement his income. Thank you, Your Honor.
And Your Honor, I'm sorry to that. I would like to state in the report, it says that there were no businesses open for the officer to review any type of film. So it couldn't be a way that he was in whatever business he just stated, or Ms. Gant just stated. There were no businesses open for the officer to even review cameras.
Again, I did not make reference to any cameras. I stated what my client informed me of, that he went back inside with the owner of this pre-game club.
And there were no businesses open.
7 a.m. in the morning, it is conceivable that a club would be open at 2 o'clock. Past 1 o'clock.
Your Honor, I just want to put on the record what's actually in the report, which states there were no businesses open. So we are asking for the bond to be remained as set. Nothing further.
All right, anything further, Ms. Gant?
Nothing further, Your Honor, thank you.
All right, it's gonna be a $500 good bond per charge, $1,000 good bond total. Stay away from 875 MLK Drive. No drugs, alcohol, weapons while out on bond.
Thank you, Your Honor.
Good luck to you, Mr. Blake.
Excuse me?
Yes.
Yeah.
You have a right to remain silent, Mr. Blake. Anything you say can be used against you. Ms. Gant?
Unless it is about your bond, I advise you to remain silent.
Yes, ma'am. It is actually about my bond. My brother gave my bond money to my girl.
I will take care of that. We discussed that. Recall, we discussed that.
All right.
Okay, well, Ms. Gant will be with you, sir. All right, who do we have next?
Your Honor, Your Honor, this is Public Defender Charles Ford. I see that there's a Jose Laredo that's been waiting to speak, but when I spoke to Cheyenne Laredo, that was in there because she had made bond. So I don't know if you want to make sure that he knows that I don't think we're going to have Miss Cheyenne Laredo on Zoom this afternoon.
Yeah, she posted bond, Judge.
Okay, Mr. Laredo, did you hear that?
Yes, sir. I'll log in off then. Thank you very much.
Okay, have a good day.
You too.
I'm sorry, Judge, but on Mr. Blake's 3 card, it's a possession of marijuana less than an ounce charge on his 3 card, but it's not on the calendar.
All right.
We received a not on docket for that charge, Your Honor.
Okay.
That's correct. We know across that charge.
Thank you.
All right.
Next, I have position 4 and 5 with the same person, Mr. Cantrell. $1,000.
Good afternoon, Mr. Cantrell. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video to help prevent the spread of the virus. You agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Cantrell, you've been charged in case 22 CR 002025H with battery, substantial physical harm, and in case 22 CR 002032H with a hit and run, failure to yield, driving while license suspended, failure to maintain insurance, and willful obstruction of a law enforcement officer. Is there a history, Mr. Howard?
13 cycles. Last arrest was September 2021. Obstruction, simple battery, terroristic threats. All right, so he got some open cases. He got open case in Fulton, possession of cocaine with intent, possession of marijuana with intent, interference with government property, and obstruction. It's 21 CP 198158. Got an open theft by receiving, 20 SC 175966. Open criminal damage to property, second degree, 2 counts, 21 SC 179895. Theft by receiving is in judicial hold. Hold on. He went to felony early and got a $5,000 good bond from what I was told. That's it.
For what charge?
Hold on. The felonies I see on here is 2 counts criminal damage to property, second degree. And it could be this driving stuff, unless that's the other charge we got him for today.
I got all my bugs reinstated, sir.
Yeah. Okay, that's fine.
And
he had a he had a 2014 capital case. He was found not guilty on that.
The 2021 obstruction, simple battery, and terroristic threats, are those open or what?
I have them open.
Sorry?
That's in Forest Park.
Okay,
That's it.
thank you. Sorry?
Yes, Your Honor. In this case, officers responded to 3600 Southside Industrial Parkway in Atlanta regarding a physical dispute. The victim, Kemarco, Kemarquo, last name Jones. He informed the officers that during an argument, the defendant hit him in the face and the back of his head with a closed hand. The victim did sustain swelling and redness to his person. Your Honor, we've heard from pretrial of this defendant's history. He does have those 2 holds, one for theft by receiving, the second for criminal damage. In the second, he also has open cases in this Clayton County for a criminal damage. In the second, he has 2 terroristic threat open charges. He had an FTA this year, and also he has a carrying a weapon without a valid license from this year. The state's recommendation is a $2,500 surety bond on the battery case with the 12/31/21 date of incident. For the second case, Your Honor, an officer responded to an accident involving 2 College Park police officers, Officer Bussey and Officer Hill. The victims stated that the defendant crashed into the back of their patrol vehicle. He hopped out and began to run. The officer for the call actually attempted to chase the defendant on foot and gave him verbal commands to stop, but the defendant refused and he continued to flee. When the officer ran the tag of the vehicle, it came back to a Janicia, Johnecia Tate, who advised that she did receive a text from the defendant stating he had just wrecked into the back of the police officers and that he was sorry. The officer that investigated the scene, he noted that the defendant did not apply the brakes before he rear-ended the victims. And when the defendant's name was ran through the database, they found that the defendant had a suspended driver's license since April of last year. And also the vehicle did not have valid insurance. For this case, Your Honor, there's currently a bond for the hit and run at $2,500, failure to yield at $1,000, driving while license suspended $500, failure to maintain lane at $500, and obstruction $2,500. The state is recommending that the bond remain as set. Nothing further.
Mr. Ford?
Thank you, Your Honor. Your Honor, my client is 25 years old. He's a high school graduate right here in Georgia at Carver High School. He's been working for Diversified Services, which is a staffing agency that he's been working for the last 3 years, and he's a forklift driver, and he really enjoys his job. He has three children, well, two, one 16-month, one 7-month, and one on the way, Your Honor. If you look at his history, he has some open cases, Your Honor. A lot of them can deal with driving offenses. As I was taking notes, he does have a stable address in Rex, Georgia. He's been in Georgia all his life, so he's not at risk of flight, Your Honor. He has strong community support. He did give me the name of, I think his one of the two, or maybe one or two of his baby's mother. Your Honor, he has to be out to try to somehow financially support these children. Now, he has several holds, Your Honor, or open cases, and that's why I'm recommending a signature bond on all counts, on all the counts here, due to the fact I think he needs to somehow systematically start to deal with these particular issues so he can get back to work and support his family. So I'm asking for, and like I said, it doesn't really matter on the amount of the signature bond, Your Honor, but I really believe, due to the fact he is a lifetime resident of Georgia, he needs to, and he's going to be here for a long time, he needs to somehow systematically start to deal with some of these open cases. And I don't believe having a bond that he will not be able to make, preventing him from going out and taking care of the other issues that are out there. He has a $5,000, has been mentioned, bond here in Fulton County. If he can make that bond, this case would not be stopping him from going out and trying, and the other jurisdictions maybe picking him up and dealing with these other open cases, Your Honor. So we're asking for signature bonds on both position 4 and position 5.
And Your Honor, the holds are in Fulton County. He is set for a jail calendar, so he will be able to deal with those cases right here in Fulton County.
Okay, thank you, sorry. For the battery, it's a $2,500 good bond. Stay away from 3600 Southside Industrial Parkway. No further contact with Mr. Jones. No drugs, alcohol, or weapons while out on bond. For position 5, the hit and run, $1,000 SOB through the jail. Failure to yield, $500 SOB through the jail. Driving while license suspended, $500 SOB through the jail. Failure to maintain insurance, $500 SOB through the jail. Obstruction, $1,000 SOB through the jail. Makes it for a total of a $3,500 SOB through the jail. No driving without a valid license. No drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Cantrell.
Thank you. Thank you, Your Honor.
Position number 12, Mr. Murray is next, please.
Good afternoon, Mr. Murray. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Murray, you've been charged in case 22 CR 002024Y with simple battery family violence. Is there a history, Mr. Howard?
This is third arrest. 2018 misdemeanor possession of marijuana. It was dismissed after he did PTI. After that was September 2021, Gwinnett County, battery DV. And he's on probation for that. The victim in that case, Asia Meadows. That's it. So he's just on probation for the battery.
Okay. Thank you, Mr. Segura.
The incident occurred on July 24th, 2021, at the incident location at 287 Fulton Street, Southwest Atlanta. In this case, for the simple battery family violence, the defendant in Asia Meadows, Asia spelled A-S-I-A, Meadows, common spelling, while in the altercation, the defendant pushed her. When contacted, she said that the two have lived together for 2 years and said that there was a physical altercation between the two in prior days, but at that instant, she did not call the police. We are recommending a $5,000 surety bond, narco, drugs, and weapons, 1-day anger awareness, a stay away from 287 Fulton Street, Southwest Atlanta, and no further contact with Asia Meadows. We want to make it known that this is not a new victim. The defendant has history with Asia Meadows. Back to what pretrial said, on 2021 family body violence, this was the exact same person. In that case, it had express conditions with no further contact and a stay away. And we want to make it known that this is a clear escalation. This case was only about 2 months prior to the September case. It was we're here for simple battery. But in this prior arrest, it escalated into family body violence. Because of that, we see we're clearly looking out for Ms. Meadows, and we have deep concern that if he's released, he could commit another act of violence against her, again, because we saw a clear altercation. Here was a pushing. At that case, we haven't ascertained as to what the serious facts, but it was enough to involve police involvement. Thank you, Your Honor.
Mr. Segura, so this case that we're here today for occurred on July 24th of 2021. Is that right?
Yes.
And the previous battery, what was the date of that?
2 months after, that was September 23rd, 2021.
September, okay. And the September 2021, what county was that in?
Gwinnett.
Gwinnett. Okay, thank you. Ms. Gant?
Thank you, Your Honor. Mr. Devon Murray is 26 years old. He has been in the Atlanta area his entire life. He has family here. Your Honor, we are unopposed to the stay away at 287 Thornton Street. Mr. Murray does not live there. He does not want to have any contact with Ms. Meadows. Mr. Murray completed high school. He also is employed at Anthony's Dover Company. He has been in that position for only about a month and a few weeks, Your Honor. He was unemployed for a period of time prior to that. Therefore, he does not have the means to pay much, if anything, toward bond. Mr. Murray denies the allegations, Your Honor. He states that he was nowhere around Ms. Meadows on the 24th. There is no escalation here, as the state contends, Your Honor. He denies the allegations, and that case is open. He hasn't been convicted yet. He denies making any statement to the police. He states that the allegations by Ms. Meadows are false. He states that her boyfriend told her to make these allegations up to file a police report. That is his version of it, Your Honor. So again, I am requesting a signature bond on Mr. Murray's behalf. And if Your Honor is not inclined to grant one, I would request a bond of no more than $1,000. And again, we are unopposed to the stay away and the no contact orders. Thank you.
All right, it'll be a $1,000 good bond, stay away from 287 Thornton Street, no further contact with Asia Meadows, no drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Murray.
Thank you, Your Honor.
Thank you, sir.
You're welcome. Who do we have next?
Position number 16, Mr. Stacy is next.
Good afternoon, Mr. Stacy. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes.
Thank you. Mr. Stacy, you've been charged in case 22 CR 002041J with hit and run and improper lane change. So your history, Mr. Howard?
11 total. He was arrested March 30th this year out of Dade County, Georgia for misdemeanor obstruction. All right. He was arrested in Texas March 10th this year for assault causing bodily injury. That's history out of Florida. Hold on. Oh, last arrest in Florida was 07. Disorderly conduct and trespass. Failure to appear, violation of probation.
That's all?
Yes.
Okay.
I'm sorry, my bad. Yeah.
Ms. Harmon?
Yes, Your Honor. On November 19th, 2021, officers responded to a hit and run call at the location of Juniper Street and 3rd Street. The defendant was not on scene, but the victim, Randolph Nickel, that's RANDOLPH, last name Nickel, NICHOL, was on scene, and he spoke with the reporting officer. He reported that he was in the extreme left lane of that on Juniper Street, and the defendant was in the adjacent lane to his right. The defendant attempted to turn left onto 3rd Street from the center lane and then collided into Mr. Nichols' vehicle. Both parties pulled over to the right side of Juniper Street to talk. However, the defendant fled the scene after returning to his vehicle and did not provide any information to Mr. Nickel. Mr. Nickel took a picture of the defendant and his license plate, and the reporting officer observed center right side damage to his vehicle and right wheel damage. The bond was set when the warrant was issued at a $4,000 total surety bond, so $2,000 on count 1, the hit and run, and $2,000 surety bond on the improper lane change. We would not ask that you would amend that amount, Your Honor. We would ask that you keep that amount in place with the following conditions: no driving except for work, no alcohol, drugs, or weapons. The basis for our bond request is the flight risk that he represents. He's a multi-state offender, as pretrial reported, with history out of Georgia, Florida, and Texas. There is recent arrest history in Texas last month, and recent arrest history in Georgia, of course. And a review of his driving record, this is a risk for I'm sorry. He has 4 FTAs on the driving record out of Georgia in 2014. And I know that's more remote, but it's still a concern. And then in his risk for reoffending is he had a 2014 citation out of Georgia for improper lane violation. So it's the same offense as we have here today. So those are the basis of our request that you would keep the $4,000 surety bond in total in the conditions that I outlined before. Nothing further from the state.
Thank you, Ms. Holman. Mr. Ford?
Thank you, Your Honor. Your Honor, my client is 43 years old, high school graduate, has some college. And I say that because he would like to work, but he is on disability. He receives a payment for disability, so he's not able to work at this time. As you've heard, Your Honor, these are a number of driving offenses, and the case at bar is really a misunderstanding. My client, as they mentioned, pulled over, and the conversation was that nothing was going to happen. It wasn't, so they were going to go about their business. And so at that point, he was surprised when he was arrested for that offense, when he thought both parties had agreed. He does have a valid driver's license, Your Honor, even though they've tried to say that he has a number of offenses. He has a stable address right here in Georgia. He's not a risk of flight, Your Honor. My client is is settled here. He's been in Georgia for 12 years. Yes, he may visit other states, but he's settled here in Georgia. He has a telephone number that he's given to me. And he has the last offense he wanted me to talk to you about, the fact that he had been tasered 4 times. And so that obstruction was just an overreaction on his part. But he has some paranoia to the fact that he has been tasered on a couple of occasions. And these are driving offenses, Your Honor. These are not violent offenses. So at this point, Your Honor, we're asking that he does receive a signature bond and be given the conditions that, yes, he can drive, but only to specific places. Those are, he has no issues with that because he does have medical appointments and things that he has to go to do due to his disability. But he's not a risk of flight, Your Honor. He's not a harm to the community. We feel a signature bond is something that could be done at this point. Or, and I'm not even going to say or something low, Your Honor. I take a signature bond because these are driving offenses.
Okay, it's gonna be $1,000 signature bond through the jail for the hit and run, $500 signature bond for the erratic lane change through the jail, which means a total of $1,500 signature bond through the jail, no drugs or alcohol while on bond. Good luck to you, Mr. Stacy.
Your Honor, was that 1,000 and a 500? Is that what I heard?
Yes.
Signature? Okay, thank you.
You're welcome. Who do we have next?
We have position number 18, Mr. Williams, please.
Good afternoon, Mr. Williams. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video? You have to speak up for me.
Yes, sir.
Thank you. Mr. Williams, you've been charged in case 22 CR 002033D with battery family violence. Is there a history? Mr. Howard?
5th arrest. Last arrest was 2019, failure to appear. Underlying charge was suspended registration, Clayton County. 2017 misdemeanor possession of marijuana, hit and run. 2009 FTA for battery. He had a battery conviction in 2009. It was a 2008 arrest, but it was convicted in 2009. That's it.
Sorry, that was supposed to have been expunged.
We see
Mr.
everything.
Williams, you have a right to remain silent. Anything you say can be used against you. Let Mr. Ford speak on your behalf, okay?
Sure.
Thank you.
Yeah, we'll take care of it, Mr. Williams.
Mr. Segura?
The incident occurred on January 31st, 2021 at 400 Fairbairn Road Southwest, apartment 325, Atlanta. Also responding to a fight in progress at the incident location. When they arrived at the scene, they made contact with Miss Bridget Stevens. Bridget spelled B-R-I-G-I-T, Stevens, S-T-E-P-H-E-N-S. Ms. Stevens stated that her child's father, the defendant, got into a verbal altercation with her. She said to the defendant that he would be leaving her house, in which she asked him to leave the house. And the defendant responded, "When I feel like leaving." Ms. Stevenson stated that she decided to stand outside of the house because she was afraid that he would beat her. Ms. Stevens also stated that she was standing at a doorway. The defendant kicked her on the back, causing her to fall on the ground. At that point, the defendant punched her right inside of her head, resulting in bruising and swelling on her face. Alongside, when the officers arrived, they noticed there was also bruising on her arm. Again, at this point, Ms. Stevens had visible injuries both on her face and her arm, and indicated the defendant did hit her. At that point, the defendant left the scene before police arrived. The state is recommending a $5,000 surety bond, no alcohol, drugs, and weapons, 1-day anger awareness, a stay away from the incident location at 400 Fairbairn Road, Southwest, apartment 325, Atlanta, and no further contact with Ms. Stevens. Making recommendations based on these facts, as also because we notice there is a pattern of violence. As the police trial has noted, there's a 2008 battery conviction and a 2009 FTA2 battery. You see there's a pattern of those both violence in that case, as well as you see violence originating in this case as well. Alongside, we also concerned that it could just not show up for court. Again, those are FTA for violence-related incidents, And again, we have another violence-related incident as well. Alongside, we're also very concerned because of a special relationship between Ms. Stevens and the defendant. They both have one child together, so we know we are concerned there might be some sort of influence from the defendant coming to her. Thank you, Your Honor.
Ms. Ford.
Thank you, Your Honor. I would like to yield to the complaining witness, Ms. Bridget Stevens. I see she's on the line. I know I've spoken with her and she's at work and she's been kind of waiting in between. And I apologize, Ms. Stevens. I thought your case would be earlier, but you're one of the last ones. But I would like to yield to her, Your Honor, before I make my presentation.
All right, Ms. Stevens, can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. Now what would you like to tell the court, ma'am?
That was an isolated incident. It was a misunderstanding. We was together, been together 14 years. Has been no issues since that occasion, January of last year. He have currently been helping me with our son. He's my primary caretaker right now for keeping my son while I try to work.
You're not afraid of him?
No, sir.
Okay.
He's been in my household since, and everything has been fine since January of last year.
Okay. Thank you, Ms. Stevens. Mr. Ford?
Well, thank you, Your Honor. I'll just piggyback on what Ms. Stevens has said. My client is a high school grad. He's 43 years old, Your Honor, and he's missed a job interview because of this incident that I think was scheduled today with Walmart, where he was scheduled to work at the warehouse as a forklift driver. And we've had a couple of people who do forklift. I'd like to just try it one time, Your Honor. But they've enjoyed their jobs. They understand it. You've heard from the complaining witness, Ms. Stevens, that she's not in fear of Mr. Williams. This incident happened a few months ago and they've been together. There's been no issues. And one of the things is, I heard the ASG talk about we feel that there's a pattern since 09 and 08. Well, the only pattern I feel, Your Honor, is that my client has done what he's supposed to do, staying out of trouble, doing things to make life better. He's had a child, 5 years. He's had a 14-year relationship. That's my client's pattern, Your Honor. He's doing the right thing. He's doing what he's supposed to do. He has a stable address there with Ms. Stevens, telephone number, email address. And when I asked the question as, do you have a relative or a close friend that you can give me a telephone number for, he listed his mother, Miss Essie Williams. And he has a close relationship with her as well. He's been in Georgia all his life. He's not at risk of flight. As Ms. Stevens said, there's no harm to the community. This is an isolated situation. Whatever took place was isolated. Your Honor, we're asking that you support or the recommendation of pretrial services, where they did recommend that Mr. Williams be released on an unsecured judicial release. So we're asking for a signature bond. Once again, it doesn't matter the amount, because I don't believe this defendant is prone to any trouble at this time or any concerns.
Okay, it's going to be a $3,000 signature bond through pretrial, 1-day anger awareness class, no further violent contact with Ms. Stevens, and no drugs, alcohol, or weapons while out on bond. All right, good luck to you, Mr. Williams, and you also, Ms. Stevens.
Thank you.
Thank you, Your Honor. Good luck, Mr. Williams.
Thank you. Number one was added in error.
Yeah, because I was about to say, we did Miss Allen yesterday.
Yeah, I came off a pretrial bond, so I think that's what these charges are.
So, do we have anyone else?
No.
No, but we have position number one, Miss Allen, but she was on the calendar yesterday, Judge. We handled her case on yesterday.
Okay, all right, thank you.
Okay, that's all we have in courtroom two. Thank you.
Okay, we appreciate it. Let's see, Ms. Bridgewater, when you're ready.
Can you hear me?
Yes.
Okay, great. All right. Again, the reset calendar is gonna be April the 19th. Okay, position number one was added in error, so please disregard that. Position number 2 is reset further notice with a $3,000 SOB through pretrial. Position 3, reset to the SAP calendar with a $1,000 total good bond. Position 4, reset to the SAP calendar with a $2,500 good bond. Position 5 is reset further notice with a $3,000 total SOB through the jail. Position 6 is reset further notice with a $2,000 SOB through pretrial. Position 7, reset to the SAP calendar with a $1,000 total good bond. Position 8, reset further notice, a $5,000 SOB through the jail. Position 9, reset further notice with a $2,000 total SOB through the jail. Position 10, reset further notice, $5,000 SOB through the jail. Position 11, bonded out, so therefore to be reset further notice. Position 12, reset to the SAP calendar with a $1,000 good bond. Position 13, reset further notice with a $3,000 SOB through pretrial per judge. Position 14 is being reset further notice with a $3,000 SOB through pretrial. Position 15, reset further notice with a $3,000 SOB through pretrial.
That's
Position-
jail, right? I got jail for Robinson. That's pretrial?
No, it's the jail. I've got jail.
Okay,
Okay.
let me change that through the jail. Okay. Position 16 is reset further notice with a $1,500 total SOB through the jail. Position 17, reset further notice with a $2,000 SOB through pretrial. Position 18, reset further notice, $3,000 SOB through pretrial. And position 19, reset further notice, $5,000 SOB through pretrial.
Number 5, I got 3,500
I-
jail.
that's-
What do you have?
Howard beat me to it. I had 3,500 signature
For
bond
position number
as well.
5, okay,
Yeah.
let's go over this then. The first charge is $1,000 SOB through the jail, and then I have charges 2 through 5 as $500 each.
I had 2 through 4 as $500 each. Position chart count 5 of $1,000 signature bond.
Okay, is that what you have, Judge? Okay.
Yes, that's correct.
Consider it done then. Let me go back over it. Charge number 1 and charge number 5 will be $1,000 SOB through the jail, and charges 2 through 4, $500 each.
Thank you so much, Ms. Bridgewater.
You're more than welcome. Are there any others?
There was one. What was number 6 again?
Number 6, I'm showing as a $2,000 SOB through pretrial.
I had 1,000, but I don't.
I had 2,000 as well.
2,000.
Okay. All
It's
right.
2,000.
All right. Thank you.
Anything else?
No.
No.
Well, thank you all. I appreciate it.
Thank you, Your
Thank you.
Honor.
Good seeing you, Judge.
We'll see you next time.